May I, Lordship?
Yes.
Lordship, I would like to mention item number 8. Lordship, conducting counsel for the petitioner is out of station. Madam,
Item 8.
item number 8. Matter may be fixed on 13, my lord,
After a week.
after a week of lies.
Your name, please.
T. Siga. T. Siga.
E. Shiva.
Siga. T. Siga.
You are not here.
No, my lord.
On behalf of?
Behalf of this Lamu man. Sorry. My lord.
Mr. E. Shiva. Learned
T. Siga.
Siram.
Siga. S-I-G-A.
Siga. Mr. S. Siga, Learned Counsel. E. Siga, Learned Counsel. On behalf of Miss MS.
Yes, Miss Lamu.
Sitting
Lamu.
Lamu. Learned Counsel for the petitioner. Praise for listing the matter after a week.
Highly obliged.
Praise the Lord. List this matter.
My lordship, I like to mention item number 25 and 26.
25 and 26.
On behalf of T. Thakur,
Yes.
lordship, we will file objections in IA.
We'll see. It's listed. You wait for your turn. You wait for your turn. It's listed for orders. We'll see.
My lord, I beg to mention item number 6 and 7, my lord. On the previous occasion, my lord has indicated that my lord was AG. This is pertaining to the Tooting case, my lord. So my lord was AG during and was the interested party in this case, my lord. So this
Yes.
matter may be taken up in a different bench.
I'm an interested party.
Yes, my lord. While serving as an AG.
Okay.
Yes.
List this matters one by one, separate one.
My lord, I have taken consent from the other side. It may be.
If I cannot take it up, it's okay.
Yes.
I cannot take it up.
Yes, my lord.
List this matter before any other bench without me.
My lord, it can be fixed on 25 of this month.
If I cannot take up, I cannot fix up also. Fix the matter also.
Okay, my lord. Deeply obliged.
My lordship, I like to mention item number 3.
Yes.
I'm appearing on behalf of M. Kato for the respondent. But due to my senior counsel is out of session. M. Kato is out of session, my lord. So can this matter may fix after 2 weeks? I have taken consent from the other party also.
This top of the list.
Yes, my lord. Actually, he was supposed to appear, but he's out of session.
Mr.
L. Rakap. L. Rakap.
And for the petitioner.
And Mr. A.K. Singh, Learned Counsel for the petitioner. Next paragraph. Mr. L. Rakab,
Yes, my lord.
Learned Counsel, appearing on behalf of Mr. M. Kato, Learned Counsel for the respondent. Submits that the leading counsel, Mr. M. Kato, is out of the station for which he praised for listing the matter after 2 weeks. Praise the Lord, after 2 weeks. No, we are not being opposed by the Learned Counsel for the petitioner. Praise the Lord, list after 2 weeks.
My lord, one more item, my lord. Item number 27 to 29. This is the analog one. This matter may fix after next week of the witness day. Next week of the witness day.
Next,
Week of the witness day. Witness day, my lord.
who is for petitioner?
My lord, I've taken consent from the petition.
2016 matter.
Yes, my lord. Actually, the council is out of session in council.
Anyway, same prayer. Then you write, since the matter is of 2016, the adjournment is granted as a last answer. List after 2 weeks.
My lord, next witness day. Next witness day.
Why Wednesday?
My lord, instructed by, my senior was instructed me.
Then Wednesday, then you do right. Same prayer for, submits that the learned counsel to the petition, Mr. M. Kato, leading counsel in the matter is out of station, for which he prays for listing the matter after on next Wednesday. List of,
Deeply obliged. my lord.
it is stated that the concern has been taken from the council to the other side. Just consider in view of the prayer is accepted and let the matter be listed on Wednesday.
Next witness.
Which date?
Next witness.
19. 19/06/2024. Mr. No further adjournments shall be granted in the next date fixed.
Highly obliged.
My lord, I beg to mention item number 10 and 11, my lord.
10 and 11.
Yes, my lord.
Yes.
My lord, matter will be list after 2 weeks, my lord.
Why?
My lord, item number 10, I'm supposed to file additional document.
Yes.
Yes, so it yet not be filed.
What you are supposed to file?
Additional document.
Additional document.
Yes, my lord.
On the prayer, Mr. El Kudu, learned counsel for the petition, list this matter after 2 weeks.
2 weeks, my lord.
11 and 12.
My lord,
Item 11 and
10 and
12.
11, my lord. 10 and
10 and
11, my lord.
Sorry, 10 and 11. Yes.
Obliged, my lord.
We'll take it the motion method first. Then we'll come back to top of the list.
May I please, Your Lordship?
Yes.
Your Lordship, this is a joint petition filed under section 498. Oh, sorry,
498.
482. 482 of CRPC for quashing of the.
Offense is 498A.
Yes, Your Lordship. Actually, Your Lordship, earlier, the charge sheet was charged under section 323 only.
Yes.
Yes, after the, then Your Lordship, in the prosecution witnesses, when IO was called, the learned magistrate has altered the charges and invoked section 506 para 1 and 498A. So trial will be proceed from the very beginning. And moreover, Your Lordship, the matter has been already settled between the
So
parties.
magistrates cannot alter the charges.
Learned trial court has altered the charges.
Direct trial court cannot alter the charges, according to you.
No, Your Honor. Actually, the matter has been already been settled between the parties.
So what is the guarantee that it's between you? We'll have to see.
Yes, Your Honor. Your Honor,
There's a case for washing or compounding of the non-compoundable offenses. We'll have to see. Just because you have compromised between you, it doesn't automatically, I mean, a ground for setting aside or quashing.
moreover, Your Honor,
Anyway, we'll wish you notice.
moreover, Your Honor, this is a totally matrimonial issues.
So,
Informant was the earlier, she was the wife and the accused was the husband only.
so if
No.
a matrimonial issue is settled,
Yes, Your Lordship.
is it an automatic quashing? Ground for quashing? Is it?
Pardon, Your Lordship? Pardon?
If the matrimonial offense is settled between the parties,
Yes, Your Lordship.
is it a ground for automatic quashing of the criminal proceedings?
No, Your Lordship, but see, Your Lordship, if the proceeding will go for a further,
Anyway, heard MS so-and-so, learned counsel for the petitioner. This is an application under section 482 CRPC, 1973. Seeking quashment of the criminal proceedings of GR case number 06 of 2016 under section 498, capital A 322 506, APC 506, para 1, 506, part 1, IPC 1860, pending before the Chief Judicial Magistrate, Capital Complex, UPA. On the basis of the compromise, call for the scan copy of the trial court record from the learned Chief Judicial Magistrate, UPA. Mr. G. Tado, learned additional PP, accepts enter appearance on behalf of the state. List after
Your Lordship, interim may be given
In
for
the-
the,
pending production of the scan copy of the trial court record, the
Your Lordship, I have an objection for interim.
further proceedings of GR case number 06 of 2016 shall remain suspended.
I have
What is
an
your
objection for interim.
You have an objection?
Yes, because this is a three-parted case, matlab three parties are involved.
Yes.
Settlements are done between two parties only. FIR may be kindly noted.
Mr. G. Tado, after consideration of the interim prayer, vehemently oppose the interim prayer on the ground that there are in the present case, 3% shall involve. However, the petition has been filed by the 2% only. Mr. Accordingly, the petition is defective for which no interim can be, no interim order can be granted. Mr. I have considered the objection and I deem it appropriate that same shall be considered on the next date. Mr. The petitioner may take steps for appropriate,
Your Lordship, all,
may take steps, appropriate steps.
Your Lordship,
List
although
for 4 weeks.
Your Lordship, although the FIR was, in the FIR, there is 3 parties, but in the charge sheet, Your Lordship, only
Thank you, madam. I have granted the interim. Yes. Where's the FIR?
Your Lordship, I have filed an application under section 438 of
Yes, I
CRP.
have said, where is the FIR?
FIR in page number 16 to 20.
15 to 20.
16.
Long FIR. Contents of the FIR. Page 19.
Everything I have is there.
No. The copy, where is your application? You don't have the application copy.
Where is your petition? Page
Yes.
19.
Yes.
Read page 19.
Sixteen to 20 page is the FIR.
We're not interested. Your page 19, you read the page.
Page 19.
This is the FIR.
I might be mistaken, your lordship.
You don't have page 19?
Yes, I have page 19. 16, 17, 15. 19, yes, your lordship. The FIR was written by that complainant Robin Cheda. That in the FIR, accused person Rahul Mishra's name is not mentioned there, and Rahul Mishra has been served a notice of 41 CRPC, 41A CRPC. That's why he has come to this honorable court to seek a relief of pre-arrest.
Then you go, you appear.
Okay, I'll go through.
No,
If
if you are saying that you have been given the summon notice under 41A, section 41A,
Yes,
go and appear. What are you doing here?
he's ready to appear.
Yes, go appear. What's there?
But the thing is that on the date of his appearance on 1/5/2024, he was unable to appear, and for this I have filed a dispense application before the session judge, but
Yes.
session judge has dismissed that application. He said that he's not cooperating with the investigation agency, but he's ready to cooperate. At the time of that on 19/5/2024, he had suffered some medical issue, and he has taken to that Lucknow Medenta clinic. There he has diagnosed some medical issue, that fatty liver disease and diabetes, and due to this he unable to work properly. Even now he is unable to work properly, and due to this incident he has certain medical issues, and his health is deteriorated day by day only because of this incident, your lordship. And your lordship, if we see the agreement paper made by the parties, his name is even not mentioned there. That this agreement paper is made on 27 March 2024, that with Rahul Ray, and the real owner name is Debojit Chutia. And Debojit Chutia also not related to the Rahul Mishra. Rahul Mishra used to use his brother-in-law's vehicle, the dumper vehicle. But his brother-in-law's dumper vehicle registration number also is not same. Only chassis number and that.
Madam, I'm not getting anything. You start from the beginning.
Then your lordship, if we see the agreement paper, here it's clearly mentioned that.
See, I have not understood anything. So you start from the beginning.
Okay, I'll read the petition then from the beginning.
It will take months together.
Okay,
If you started reading the petition.
Okay, your lordship. I'll read out the para number 2. The brief fact of the case is that on dated 27/3/2024, an FIR was lodged by 1-3 Robin Cheda of Gopur Itanagar against 1-3 Rahul Ray and his associate, alleging inter alia that on dated 27/3/2024, he met the accused Rahul Ray and his associate at Dikrong Hotel, Bandadeva, and signed an agreement to provide a heavy vehicle like dumper, etc., and paid an amount of rupees 3,60,000 only, and 40,000 only via online payment, totaling amount rupees 4 lakhs. And executed formal agreement. After payment, the said Rahul Ray, in pretend to refill the vehicle, did not turn up and avoided their phone calls. And later the complainant and his relatives has stressed out them from hotel at Bandadeva, who were booked hotel rooms in Dikrong Hotel, Bandadeva, in fake identity. Your lordship, here also they have hotel room in fake identity. That this Rahul Ray is only try to swindle the money of the.
Have you understood yourself?
Yes.
After reading that page?
Yes, your lordship.
What you have understood? Tell us.
That Rahul Mishra, applicant Rahul Mishra, is completely not involved in this case, your lordship.
Okay.
That's why he filed this bail application.
Yes, Your Lordship, initially, the present applicant has been granted bail by the learned court below, interim protection, but in the meantime, he's not.
438.
Yes, Your Lordship, and he has not cooperated with the investigation, he didn't appear. And on that context, Your Lordship, his bail was cancelled, Your Lordship.
Cancelled.
Yes, Your Lordship.
Then.
And now they approach this honorable court.
Your Lordship, during that time, I have filed it.
Maintain it.
Your Lordship, they can approach, if they are saying that there is a medical ground or
Yes.
medical aspect, then they ought to have taken that ground before the learned court below, because they have already protected earlier, Your Lordship. Only because of non-cooperation, not appearing before the IO, the bail was cancelled, Your Lordship.
Your Lordship, this time he's ready to cooperate and he's ready to appear before the IO.
You go and tell the session judge.
But I have filed this bail petition before this honorable court.
We'll allow you to withdraw. You will give you a liberty to approach the sessions court. All right.
Okay, Your Lordship.
Are you sure?
If we'll grant this interim relief from this honorable court, it will be very
Without
good for us.
if you withdraw this, how can we grant the interim relief?
I don't want to withdraw, Your Lordship. If the matter
So
proceed
we'll
from
only
this,
call for the CD because it appears that
okay, Your Lordship, but grant him interim relief.
judicial order that you are not cooperating.
No, this time he'll cooperate.
Towards the investigation.
No,
So we'll see
that is
we'll call for the CD.
that
and
is
we'll
the
see.
statement of the IO.
Heard MS
That is the bare statement of the IO, Your
Learned
Lordship.
counsel for the petitioner. List of next para. This is an application under section 430 of CRPC, 1973. Praying for grant of privilege of pre-arrest bail to the accused person Sri Rahul Misra in connection with Bandadua PS case number 20 of 2024 under section 420 public 34 of IPC, 1860. Call for the case diary. Scan copy of the case diary. Mr. T at the London additional PP appears for the state. List after 3 weeks.
Oh, pardon, Your Lordship.
List after 2 weeks or after a week.
After a week, Your Lordship.
After a week.
Okay, oblige, Your Honor.
Obliged, Your Lordship.
Your Lordship, may I? Your Lordship, I am on behalf of conducting counsel Tony Patin. Unfortunately, Your Lordship, he had to leave Itanagar early this morning due to some urgent matter. That's why we have already informed the
No, it's
respondent counsel.
2012 better. No,
This
it's-
matter, Your Lordship, may be fixed day after tomorrow. He will return by tomorrow evening.
We'll
And
hear it today. Who appears for the other side?
Senior counsel, Binter Picha, sir.
Hmm?
Binter Picha, sir. I have already informed him.
We're not adjourning. What's there? 2012 better. You have the brief?
No, Your Lordship. Your Lordship, I have just been informed that Binter Picha, sir, is occupied there at court 1.
We'll take after some time.
Much obliged.
Go through give the second copy to him.
Please, Your Lordship.
Yes.
Lordship, matter is only on the issue whether or not the post of the RSO was a reserved or unreserved post, Lordship. Initially, in 2015, by a DPC, the DPC had cleared my name for the post of the LRSO. That time in the DPC, they had said that since the post is a reserved one, so therefore we are recommending his name. So I was appointed. But that order was challenged by somebody else, not the respondent here. saying that because that post was an old one, so yes, because that post was an old one, so therefore the previous pre-amended RR should be followed.
Just hold. In Ranagadam, I think, do you have that order of that?
Yes, I have annexed that.
I'm not there. Did I appear for that?
Lordship,
Just
I'll
check
have
it
to
out.
check. I'll have to check. Sorry, but Lordship, that is only for Lordship citing the facts, but otherwise it has nothing to do with
Just check
Ranangadong.
it.
Yes.
Yes, Lordship has appeared
Uh,
before Justice Sumanshin.
As a petitioner.
Respondent.
It's the whole problem.
Page
Uh,
38.
yes.
I was also under the impression.
No,
I did not realize.
Page 38.
Page 38.
I didn't go through that, but I.
Yes, Lordship.
Yes, for the respondent.
No, here it's written G at the.
Theatre,
Yes,
Theatre.
page 38.
theatre.
Yes.
Yes, sorry, madam. Anyway,
I have never served as the additional senior governor.
maybe it's, maybe the,
Yes,
I think,
so no issue.
nice, proceed.
Yes.
So Lordship, that order was set aside, not on merits.
Your promotion.
Yes,
Your promotion.
in 2015.
Yes.
I'm just coming to how this case came about. In that case, what this honorable court has said, because the post is an old one, so therefore the DPC should be cancelled and DPC should be held. Second DPC should be held on the same post, but following the old rules. That is what was said in the petition filed by Ranangadong. Then, Lordship, based on that, the DPC was convened again in 2017, but this time on the same post, they have said that the post is an unreserved one. So therefore, the respondent, private respondent was given the promotion and I was reverted back to SK. That is the whole case. Lordship may see the DPC, the first of all, the minutes of meeting, page 35. This is the DPC on the basis of which I was promoted earlier. I'm citing this only because in the DPC, they have made a categorical finding that this post is of a reserve one, Lordship. Lordship, the
Page 36.
page 36, yes. Para number 6. So
Yes.
my name was recommended in paragraph 7.
That
Thereafter,
was the officiating.
yes, officiating, but the fact remains that the finding was that the vacancy is, the post is reserved for APSC candidate.
So till he completes the qualifying service of 15 years.
Yes,
On which this promotion shall extend regularly.
yes. But this was, of course, set aside by the order of Ranangadong. Ranangadong's order is at page 38. The operative portion is at page 42. Para 9 and 10.
Just wait.
But the issue, it was not an issue whether or not the promotion was right or wrong in view of whether the post is a reserve or unreserved. That was not the issue. Page 42. Para 9 and 10.
Yes. Just read it.
As noted
Yes.
above, in the present case, the DPC has not made any recommendation for regular promotion in favor of the respondent number 4. The recommendation of the DPC was evidently of a contingent nature, Since the respondent number 4 admittedly did not meet the eligibility norms under the rules, the said recommendation of the DPC therefore cannot be the basis for regular promotion of the respondent number 4 to the post of the LRSO. If the department wants to give regular promotion to a candidate to the post of the LRSO, then the candidature of all eligible candidates will have to be considered as per the relevant service rules, which was holding the field on the date on which the vacancy arose, and only those candidates who meet the eligibility norms under the rules and comes within the zone of consideration can be considered for regular promotion. In the light of the above, in the light of the observations made herein above, this writ petition stands disposed of by issuing direction upon respondents number 1 to 3 to constitute a fresh DPC for considering the case of the eligible departmental candidate for regular promotion to the post of the RSO as per the rules applicable in the case. It is made clear that the order dated 3/11/2015 would be counted only for the purpose of officiating promotion of the petitioner, and the same would not confer any right upon the respondent 4 onto the post of the LRSO.
Respondent, you are
I'm respondent 4. So basically, it was only on that that order of promotion was set aside.
Is officiating.
Officiating, saying that it was of a contingent nature.
What about the rule applicably of the rules?
That was also, Lordship, that was also
Where it is?
page 40. 40 and 41.
7.
41 would be better,
Para
Lordship,
7.
para 8.
Para 7.
Yeah, yes. It was basically their contention. That
Third line, it is therefore.
Yes.
This is the finding of the court,
Yes,
relying on the judgment.
yes.
Rule 2015. No
Yes.
problem. Application.
May I read, Lordship, or page 41?
Yes.
So basically, thereafter,
Your promotion was.
my promotion was set aside, and at page 46 is the
Deficient.
minutes of DPC.
Yes.
May I read, Lordship?
Yes.
The Honorable Gauhati High Court, Itanagar Permanent Bench, in its order dated 15/5/2017 in WPC 170, AP 2016, in the matter of Ranangadong versus State of AP and others, has made it clear that the promotion order dated 3/11/2015 in respect of Sri Kago Doni to the post of DLRSO would be counted only for the purpose of officiating promotion. The same would not confer any right upon him on the post of DLRSO, and has directed the Land Management Department, Government of Arunachal Pradesh, to constitute a fresh DPC to consider a case of the eligible departmental candidate for regular promotion to the post of the LRSO as per recruitment rules applicable as on the date of vacancy of the post. In pursuance of the said order, the Land Management Department has constituted a departmental promotion committee with the Secretary, Land Management, as the chairman, and the Secretary, Sports, and the Director, Land Management, Government of Arunachal Pradesh, as its members. The vacancy of the said post of the LRSO, District Land Revenue and Settlement Officer, Group B, gazetted in the Department of Land Management arose consequent upon creation of one additional post by order dated dated 10/12/2012. As such, the applicable recruitment rules to the post on that period is the Land Revenue and Settlement Officer, Group B, gazetted recruitment rules 2006. As per column 12 of the recruitment rules, the post is to be filled up from amongst plain tabular, now redesignated as Assistant Survey and Settlement Officer, and Recorder Kanungo, RK, and Supervisor Kanungo to the post of the department who have rendered 8 years of regular service. in the grade and possessing class 12 and certificate course in servant settlement from a recognized institution. As per records, the candidates who meet the eligibility norms under the said rules and comes within the zone of consideration is as follows. Number 1, James N.T. This is the private respondent. Number 2, Kagodoni, myself. Then Ranang Adong, then Tama Dakpe and Mipang Nangkar. As per reservation roster of APST, non-APST, the present vacancy is non-APST. The department has submitted all the records as the as the recruitment rules, seniority list of officials in the feeder grade, available SCRs, NOC, vigilance clearance, and other documents before the committee for examination and consideration. As per the recruitment rules of 2006, James N.T. is eligible for promotion as he has all the requisite qualification. Ranang Odong is also
Yes, they are saying that it's non-APST.
Yes,
It's not reserve post.
yes, they've said this now. Earlier, on the same post, they say it's a reserve post, Lordship.
Somersault.
Yes, that's what I'm saying. Lordship,
Just find out you are for James N.T.
Yes, ma'am.
I think I have appeared for him somewhere, in some cases, not this case, maybe, most probably.
But
Will it not
I,
appropriate?
no, I did not find.
Maybe some other cases, but then I vaguely remember. Rana Ngadam or something like that is.
Ranangadong had
James
filed
N-
several
yeah.
cases, could be.
And James N.T. also.
Yes.
James N.T., my lord, has not appeared.
Somewhere, not in this case.
If I'm not mistaken, no,
The
this
first
is not.
case is, which I care, Rana Ngadong is at page 20. My brother Jini, now the honorable MLA, appeared for the standing council. Therefore,
Actually, Ranangadong has filed several cases, not just these 2 cases. So I am not, I don't know.
Will it be proper if suppose I had appeared somewhere in the case of N.T. James?
but from our side, from the records, we could not find
May
anything
not
that
be
might not
here,
have
but in
appeared.
some other cases,
Or
if
it might show.
he or he was my client, then it may, suppose you never know. Anyway, do we have the records?
No, my lord.
I had some doubt. Somewhere, some service matter I appeared for. That's why I have a.
Lordship,
If you don't have any problem,
No, we
since
don't have
it's
any
not
problem,
record, it's not
because-
evident in the record.
yes.
There's
But the
nothing in
time-
the record. If you don't
no.
have, I will proceed. But
Percy,
if
my
you
lord.
have any doubt, then
No, we don't have.
Since
Percy,
I don't have
no,
any
that-
information, I don't know whether to have doubt or not.
because I had some little doubt.
Matter may be taken up next week then.
Can you find it out?
Rana
Not next
Ngadong,
week.
huh.
We'll take it up tomorrow or day after.
Nangadong has filed several cases that I know, but I don't know how many cases.
Well, just in 1 minute, I think we can resolve from here.
No, very old cases.
But Milord, here the issue is different. Suppose like this is relating to the promotions only. But I don't find anything on the records that my lord have given legal opinion or appeared as a counsel for the state.
Mr. Mao might know. Sunil Mao might know.
Yes.
He has filed several cases on his behalf. So far as I know.
Adam and
Yes, he
James.
might know, yes.
James N.T. huh? James N.T.
I can recollect, Ranangadong has filed a land matter regarding compensation.
No, that may not be.
Not compensation. If it is anti-gems, it will be service matter only.
Yes, if it is enthusiast, then it will be service. But
No, Ranagada, I'm not. I have a doubt on James N.T.
James N.T. No? James NT.
Ranagaran is clear now.
Ah.
Maybe both they were involved in that.
Well, the bench assistance is working on that.
He's there, still he's there.
James
Must be
NT.
there, James NT.
No, he's
Retired.
retired.
So next you will be there.
Yes. Yes, Lordship.
It's vacancy is there.
Vacancy is there, but since I've been reverted back.
No, you'll be, there will be fresh consideration now.
Yes,
Then what's there? It should be, it will be merely academic,
yes, of course.
isn't it?
Yes.
Academic may not be, because I was given promotion.
No, you'll not be disturbed. You have retired now. Problem is you have retired now.
Suppose if my lord allows allows the Kagodoni's petition, in that even I will be prejudiced for the matter that I was given promotion, although I have retired, but I will have the predicaments of not getting certain financial benefits as a
So
DLS.
that's why I'm asking, at this stage, if we even find that you have a merit in your case,
Yes,
since the man has retired already,
yes,
we may not pass any adverse order against him. Is not it?
yes,
My lord can make a small observation that in that given, without going into the merit of the case, then my lord may like to observe.
Let us do one thing. We'll continue tomorrow at any stage. Let us iron out this issue that whether I appeared for Mr. N.T. James or not. You can, if you are, do you have any contact now?
No,
You may make a call also. If I had appeared in some of his cases, you'll definitely remember.
Well, from the registry, we'll find it.
And we may, in the meantime, let them find it out.
Yeah.
We'll finish it tomorrow. And if he has retired, we'll direct you for press deficiency.
yes, Lordship.
Without
Since
interfering.
you have suffered, it's okay.
Yes, without
You're ill luck.
without interfering with the last
Yeah.
DPC where I was promoted. That will balance the.
He's
equity
asking me to
for-
surrender.
I know the in between department has conducted so many DPCs.
Yes,
And their DPC also is put to challenge before this honorable.
yes.
There are 2 cases pending before this honorable.
If you have conducted DPG, what happened to this present petitioner?
Get the instructions.
I'll get an instruction on that.
Tomorrow, we'll take it up tomorrow.
Yeah.
We'll finish it up this tomorrow.
Oblige.
If possible, you bring all those records also
My lord.
tomorrow. All right.
Yes,
In the meantime, you also try to find
No,
out,
no, that's why it's like
all of you,
I was,
and I'll request them also.
I asked.
And you bring the instruction along with the records. Suppose in between, during the pendency, if there were DPCs and all,
Yes,
whether why his case has not been considered.
maybe because my lord, because. of
There was
the
an
tendency
interim
of
order
this,
in my
yes,
favor. There was an interim order in my favor.
Your favor.
Yes,
Saying what?
staying the operation of that reversion order.
Okay.
No, promotion order of MP James was stayed.
Oh.
No, the promotion of my client was stayed.
The operation of the interim order, 9/3/2018.
Yes.
Your promotion.
Yes, my promotion has been stayed.
Then you have to, there's a stay
Yes.
against your promotion.
Against my.
You have to fight it out. It's not that easy. What I thought there's no stay, and you have been allowed to
No, that's why.
retire on the promotional post.
No, that's why, my lord, I was trying to refer to Indra Sane case and then that Nagraj case. Then once this Indra Sane and Nagraj case are clearly distinguished, then followed by that Maharashtra reservation case. And then R.K. Balla case where this roster was implemented. Here it appears something is
Not R.K. Balla, R.K. Sabarwal.
Sabrawal, yes. Sir. No, that particular judgment
Will not go that.
Everything will
much
depend
depth.
upon the government
Will not,
on
will
whether,
not go that much deep into. We'll just try to
No,
resolve the
just-
issue.
on how the character of a post changes,
No,
only on that.
No, Milord, it came to my mind
Yes,
just
you have
now.
to understand, you might have, you might be prepared,
Yes, my
but
lord.
then the only issue is, according to her,
It was earlier.
it was a reserve post.
Yeah, it-
When suddenly, when there was a DPC, you have said that this is not a PhD.
That was a mistake. That was corrected only in the subsequent DPC, my lord.
Okay, we'll see.
They-
That was not the issue in the earlier proceedings.
Yeah, that was not the issue.
That was not the issue.
Earlier issue was that whether the amendment rule or the
Yes.
old rule will apply.
2015
That was not the
will
issue in the
apply.
earlier proceeding
Yes.
because two of the parties, or both the parties were APSC.
Yes.
So that was not the issue.
No, but that's why there is a roster, 100-point roster implemented. So suppose if the APST post, if a person is not eligible, prima facie, I can see that in the previous officiating promotion which he was given, he was not ripened for the promotion that point of time.
No, no, in your,
Yes.
in your DPC, in the subsequent
that-
DPC, they
that's-
said the petitioner is also equally eligible.
No, he was not.
No, it's.
No, no. Because in the earlier, because
Under DPC,
in the,
he was.
and the
he was
earlier DPC, let me submit.
14 years.
No, no, no. In the earlier DPC, because the new 2015 rules were followed, in the 2015 rules, the service rendered should have been 15 years, Lordship. But since this is in as per the old rules, that is 2006 rules, as per this only 8 years, Lordship. So therefore, there is no question of my ineligibility at all. That is the only reason, Lordship. In fact, none of the candidates were had completed 15 years at that point of time.
Okay.
That was
requisite
the-
qualification.
Yes,
Requisite.
requisite qualification was 15 years. In fact, I was the one having the most number of years, even though it did not reach 15 years. So that is why I was given that promotion. But
No,
now,
page 46, you just, serial number 8,
Lordship,
serial number 8, page 46.
yes. Yes. Kagodoni is also eligible.
Eligible.
Eligible because here the requisite qualification is 8 years as opposed to 15 years as stated earlier.
In
That is
fact,
why.
that
No, that's why,
46
whatever
rules.
they have said, they have applied the rule 2006
6 rules.
rules.
Six
only.
rules.
So
As per
both-
6 rules, everyone is
both were-
eligible.
Both are eligible only because the post according to DPC is non-APST, therefore GEMS. has been
Yes,
given.
yes, yes.
That's all.
Eligibility is not even a question here.
That is, that is,
I have clear that is stand in my this affidavit at number 12.
no, you will have to
Sorry.
go deeper.
No.
So you have to show
Yes, yes.
that's why record will be required. How many posts are
Then
there?
in that case, my lord.
It's not simply that DPC says, and you said that by way of affidavit, that we have rectified. It
Yes.
was a mistake. That will not suffice. We'll have to see the records, how many posts were there.
How many are
persons
filled
have
up?
filled up from APST, no MST. That's the reason this
Because,
court would like to see
Milord,
the
that
record.
column 12,
Then my lord, to trace the record, my lord, in area, my lord, more or be possible, my lord, may not be possible.
You try it tomorrow.
Milord, that column 12 of the RR says,
Simple, we'll decide on the basis of the record. Your
Yes.
affidavit may say so many things.
affidavits are not gospel truth. My lord also knows that.
No, we believe the affidavit is more than the gospel truth. But then it depends on the case. The nature of the case is as such, you will have to depend on the record.
There was mistake in this calculation of this roster post system.
That's why
That
we
is why it
will
was rectified. And I
we'll recalculate it.
clarified.
If you have correctly calculated, it's okay. We'll agree with you.
That's why, my lord.
That is there in my para 12 of my affidavit, my lord.
Let,
You have
let them bring the
calculated-
records, Lordship.
They, have you annexed all those, how many posts are there?
Yes, my lord. It is my affidavit.
No, my lord, that will be very interesting because the petitioner was not ripened. In this case, the government has excised the power. So therefore, the rigor of general, section 14 of the General Clause Act will come into play. Power to excise from time to time. So the government has rightly done, and to challenge the DPC, Unless or until, unless there is prima facie case.
Sir, in
of
that case,
arbitrariness.
in this case, no one would be, will have a right to challenge any order of the government.
No, Lordship.
Then-
From page 26 of the affidavit, it's only the DPC minutes and all.
Yes.
Where? Just-
Would like to see the records.
Para
You
to-
bring it tomorrow.
You bring it tomorrow.
Heard
Obliged.
MS and Learned Counsel for the petitioner. And also heard Mr. D. Kamduk, Learned Counsel for the Learned Standing Counsel for the Land Management Department. Mr. For the state respondents, Mr. and Mr. T. Tara. Learned Counsel for the respondent number 4. Next paragraph. Considering the nature of the considering the issues involved in this writ petition, this court deemed it appropriate to call for the records. Accordingly, the learned counsel, standing counsel, Mr. D. Kamduk shall produce the records. Tomorrow.
Grateful.
You call up now. Yes. Let them arrange.
Obliged.
May I, my lord?
Yes.
My lord, we kindly appreciate, my lord, the counsel for the,
May I be your lordship? My lord,
Yes.
432 application, my lord. This for quashing of the criminal proceeding pending before the Ghana Judicial Magistrate. My lord, here allegation is there is 2 allegations, my lord. One is, my lord, using a fake work experience certificate, and another is, my lord, fake registration certificate of the firm.
You have admitted.
My problem is that I am a petitioner before your lordship is 80 years old.
Is it ethics 471? Yes. Then go.
My lord, 471 is there, my lord. Kindly see.
You, sir, you have admitted.
My lord, I am not the
Not
maker.
only admission, subsequent conduct. You said you have when you found that this is a fake and forged one.
Immediately I have withdrawn.
Withdrawn.
From the bill.
Therefore,
Yes, my lord.
no
This is a
quashing.
80 years old man, my lord. He is suffering. He is a bad
We
present.
feel for all,
Problem
that
is that it is a bad
that is
present.
all human consideration. What is the law? If,
No, of course, it is
even on
not.
admission and if Ramavasi, if there is a incrementing materials against
No.
an 80 years old, or that will show us even 70 years.
My
Will
lord,
immediately question.
section 464 is say the makers of the document, not the user, man.
Sir,
I-
this is a matter of trial. You go there. On your own admission, you cannot quash it.
No, the problem is that he is a bedridden person. Facing trial is also a problem. May I pray
What is
that
the stage of trial?
My lord,
We'll direct it
It-
for expeditious
no,
trial.
till that the charge has not been framed, because I could not appear.
Why you are not?
No, I could not appear 2-3 days because of my old age ailment, my lord. That is an admitted fact.
Sir, no case for quashing.
नहीं. Lordship, may kindly stay for some days. I will.
I need not go through the records also. On your own petition, it's clearly,
My lord,
it's
actually-
fairly you have established your guilt.
Yes, my to my understanding, my lord, section is defined first document, section 464. And
Will say-
460,
It's
471 is.
that's the reason. That's the reason that
Makers.
the
I have not used. my lord.
prosecution may succeed, may not succeed. Take
No.
that advantage, but it's definitely it's not a case for quashing.
Moment I came to know, my lord, is the fact I have not used. I have not used that document. It
That's a
was made
matter
by
of,
somebody else.
matter of trial. You said yourself that coming to know that it is not
Yes.
genuine, you have withdrawn from the
Bid process.
bid person. We're not on that. We're on, it amounts to admission only. Anyway, I'm not
But-
saying,
I'm not the makers, my lord. The section 464 is said the makers who made the document.
sir, that's why I'm saying it's a matter of trial.
Not,
You have a good chance before the trial.
that is true, my lord. This 80 years old man, my lord. Let me try, my lord. Let it come after about 2 weeks.
Yes,
I feel sympathy for this man, that's why, my lord. Otherwise, I could not fight. After 2 weeks, my lord.
but I'll record my prime facie view.
Kindly examine for that.
I'll record it and I'll adjourn. Anyway, what do we say?
My lord has already explained it. But I think
Had Mr. S.K. Devi, learned counsel for the petitioner, and also had Mr. O. Pada, learned special. Are you a standing counsel or a special PP?
public prosecutor.
Special PP for SIC? Within bracket vigilance. And Mr. K. before, learned counsel for respondent number 2. Next para. After arguing the matter at some length, Mr. S.K. Devi submits that he may be granted for the few days to go through to obtain instruction for which he requests for listing the matter after 2 weeks. Should I record my prime facie view?
No, my lord. It will escape my court.
Prayer not being objected to by learned counsel for the respondent. Is allowed. List this matter after that. Allowed, huh? Accordingly, let the matter be listed after 2 weeks.
I am deeply obliged.
2 weeks.
Obliged.
My lordship.
Your lordship, in this
Yes.
case, we might need the TCR, your lordship. The charge sheet has already been filed. We'll be needing the TCR, your lordship.
We'll have to call for
We
it.
will have to call for that.
Call for it. Okay. Or Mr. Arimo, learned counsel for the petitioner. And also, MSTG, learned assistant PP for this state.
Lordship,
It is informed that the charge sheet has already been filed.
Yes.
Against the petitioner.
Lordship, I have an interim prayer, Lordship. On last
Accordingly-
occasion, my interim prayer was
Accordingly, call for the trial court records
Yes.
from the Court of Learners,
Principal Magistrate Juvenile Justice Board,
Huh?
UPI.
Juvenile Justice Board, your lordship.
Juvenile Justice Board. Call for the charge
UPI.
sheet has been filed.
Yes, your
Yes.
lordship, they have.
Investigation is going on, Lordship.
No,
Investigation means trial is going on
Trial is
before the JJ.
they have, in their additional affidavit, they have filed the charge sheet. On the earlier occasion, they did not file a charge sheet, your lordship.
Charge
Subsequently, they,
sheet before whom?
against the accused, your lordship.
Which court?
Juvenile Justice Board at UPI, your lordship. Deeply.
List after 2 weeks.
Lordship, I have an interim prayer, Lordship.
What's that?
Investigation before JJB may be.
Juvenile Justice. Wait for 2 weeks. 1
Lordship-
week, in that case, 1 week.
Your lord,
When we will see.
Lordship, in this case, there is one unique thing is that the complainant informant victim, they did not turn up for several months. It's been a 7 month, Lordship.
Okay, we'll see. When is the next date?
Next date, July 1.
Okay, so we'll fix after 1 week. All right?
Deeply.
But on last occasion, CD was returned and
Yes.
given direct to produce the same, but we have not received the case diary, Your Lordship.
What's this?
Your Honor, this is a petition for quashing of FIR on the ground of settlement between the parties. On the ground of settlement between the parties.
What is the offense?
FIR is in page number 21, lecture 1.
Yes, last time. Yes, there he was returned.
Yes, Your Honor.
Yes, Your Lordship.
Is yet to receive now.
Next time may be given.
What do you say? Otherwise.
Your Lordship, otherwise, Your Lordship, one peculiar instance is there in this case. Your Lordship may kindly come to section 75 and 79 of the JJB Act. Otherwise, for the other sections, Your Lordship, we do not have much objection, but the 75 and 79, it's create hurdle, Your Lordship. Your Lordship, 75 and 79. The case is registered under 75 and 79 of the JJB Act as well.
It's all one, the new one. Same, this is same or what?
Same, Your Lordship. I will find it out. Your Lordship. $75, Your Lordship. 75, no doubt, Your Lordship, it's against the accused. Your Lordship, may kindly come to 79. Exploitation of a child employee, Your Lordship. It's a non-obscenity clause, notwithstanding anything contained in any law for the time being enforced. Whoever ostensibly engage a child and keep him in bondage for a purpose of employment or withhold his earning or uses such earning for his own purpose shall be punishable with rigorous imprisonment for a term which may extend to 5 years and shall also liable for 1 lakh rupees. Now here, Your Lordship, the mother is the complainant and she engaged the minor, Your Lordship, a child, Your Lordship. So in fact, she is one of the accused if we go through section 79.
Your Honor, there was two child. One child age was 17 years old. And according to Your Honor, Child Labor Act, above 14 years can be engaged in domestic helper. And another one is 13 years. And 13 years old child, the child was not engaged in domestic helper work. He was just bring to the house of one of the alleged accused.
Suppose if investigation reveals that 13 years old child was engaged.
He was just
Then-
brought by the mother of the child, as already his elder brother, 17 years old, was already engaged here, and one of his sister, whose age is 29 years, she was also there. Here, Your Honor, that one of the accused person, she is the wife of assistant engineer of PWD. She stay with her husband at Changlang, and Your Honor, this entire house of Naharlagan was taken care by the one of the younger sister of complainant. And Your Honor, this section that the 79 of this JJB Act does not apply here. Because Your Honor, as per the section 2 of the Child Labor Act, the person who have attained the age of 14 years, he can be engaged as domestic helper in the anywhere, Your Honor.
Your Lordship,
And
this
that-
79 has a non-obscenity clause. It says notwithstanding anything contained. It's an overriding effect. This is the issue, Your Lordship.
And this 13 years child was not engaged yet. He was brought from the
According to you, according to you,
yes, Your Honor.
according to you, then
Yes.
in this case, we'll see the case.
Yes.
Not Mr.
Ebodo.
Ebodo, then counsel for the petitioner. On 24/05/2024, after hearing the parties, the matter was adjourned and the case diary was directed to be returned, to be produced on the next date of hearing. Today, Mr. T. at the learned additional PP submits that he has not received the case diary. Case diary, for which he prays for this 2 days time to obtain the case diary. Praise the Lord. List this letter on 14,
Okay, Your Lordship.
on 13, on 13,
14.
306, 13, no, 13, 06/20.
Your Honor, on 14,
We'll see.
on 14, on 13, I have some matter and outside the district. 14 or
14. 14 to it may not be possible again.
14 is fine.
Anyway, 14 we'll see.
Okay, Your Lordship.
14. 1-4.
yes, sir.
Obliged, Your Lordship.
May I please, my lord?
Yes.
Lordship, on the last occasion, the state was asked to clarify whether hearing the victim or party authorized by the victim is necessary in for
Yes, madam. What is this?
This is the Lordship, Jagdish Singh versus Ashish Mishra Lordship. Here Lordship, the parameters is there Lordship that court while deciding the application for bail should refrain from evaluating and undertaking detailed assessment of evidence that may be relevant for the court may examine prima facie issues with any reasonable grounds whether it competent of feasibility of offense itself. And Lordship here Lordship also Lordship the victim's right Lordship. As per this lawsuit, the analysis there lawsuit, where a victim is defined under section 2 W of the Court of Criminal Procedure lawsuit, entitled to be heard at stage of execution of bail application of an accused. The victim's right to be heard.
Where it
The
is?
page 5 lawsuit. May lawsuit, para 16 lawsuit. Until recently, criminal law has been viewed as a dimensional plane when the court were required to educate between the accused and the state. The victim, the de facto sufferer of a crime, had no participation in the adjudicatory process and was made to sit outside the court as a mute spectator. However, with the recognition that the ethos of criminal justice dispensation to the prevent and punish crime had surreptitiously turned into back on the victim, the jurisprudence with respect to right of victim to be heard and to participate in criminal proceedings began to positively evolve. Moreover, lawsuit on the para 9 lawsuit or 19 lawsuit on domestic front, recent amendments to the CRPC have recognized a victim's right in the Indian criminal justice system. It's a para 19 lawsuit. The genesis of such rights lies in the 154th report of the Law Commission of India, wherein
Radical recommendations on the aspect of compensatory justice to victim under a compensation scheme were made. Draft Committee on the Reforms of Criminal Justice System in its report in 2003 suggests way of means to develop a cohesive system which all parts are to be worked in coordination to achieve the common goal of restoring the lost confidence of the people in the criminal justice system. The committee recommended the right of victim or his or her legal representatives. It to be to be implemented as part in every criminal proceeding where the charges punishable with 7 years imprisonment or more. Para 19 or 20 also lordship, it was further recommended that the victim be armed with the right to be represented by an advocate of his or her choice, and if he or she is not in position to afford the same, to provide an advocate at the state expense. The victim's right to participate in criminal trial and his or her right to know the status of investigation, that take necessary steps or to be heard at every crucial stage of criminal proceedings, including at time of grant or cancellation of bail, were also duly recognized by the committee. Repeated judicial intervention coupled with the recommendations made from time to time as briefly noticed above prompted the parliament to bring before the Court of Criminal Procedure 8, which not only inserted the definition of victim under section 2WA but also statutorily recognized various rights of such victims at different stages of trial. Lordship, in the para 44 lordship, needless to say that the bail application shall be decided on merits and giving adequate opportunity of hearing to the victim as well. If the victim was faced, lordship, para 44 lordship.
44.
44 lordship, page 11 lordship. May I, lordship. Needless to say that the bail application shall be decided on merits and after giving adequate opportunity of hearing to the victims as well. If the victims are unable to engage the services of a private counsel, it shall be obligatory upon the High Court to provide them a legal aid counsel with adequate experience in criminal law at the state expense. Lordship, this lordship, citation lordship, it speak about the lordship victims, lordship, right lordship. And it's a common as a bail lordship. It's under lordship. Article 21 also is a right of a person lordship. It cannot be infringed.
Yes.
Lordship, Lordship may kindly appreciate the fact that this particular case, which the learned counsel for the state is relying, is Jagjeet Singh versus Ashish Mishra. The fact of the case is, this case is related to Lakhimpur Kheri, Lordship. Lordship is aware of the incident at UP, Lordship. Now, this particular case only gives, it only provides for vested interest of the victims in every stage of trial, Lordship. In this particular case, Lordship may kindly appreciate that this, in this case, while the bail hearing was proceeding of bail hearing was done, Lordship, the victims were not allowed to participate in the bail hearing, Lordship. Now, even the victim has requested, in fact, they have made an application before the court to reconduct the hearing of that bail hearing of the victim, Lordship. Now, in our case, Lordship,
in interesting thing is, in our case, the victim has not been participating despite notice from our side as well as from the state side, even before the trial court. And Lordship, with this regard, Lordship,
No, no, for that, you are not saying, you were saying that, since the charge sheet is under section 376
subsection 2, yes, Lordship.
it is not required.
Yes, Lordship. I'll come
But
to
then
that.
this Ashish says so,
Yes,
para 30, you read para 30.
Yes, Lordship. It will be beneficial at this stage to recapitulate the principle that the court must bear in mind while deciding an application for grant of bail. This court in Basanta Kumar Sarkar versus Ashish Chatri, after taking into account several precedents, elucidated the following. However, it is equally incumbent upon the High Court to exercise its discretion judiciously, cautiously, and strictly in compliance with the basic principle laid down in a plethora of decisions of this court on the point. It is well settled that among other circumstances, the factors to be borne in mind while considering an application for bail are whether there is a prima facie or reasonable ground to believe that the accused has committed, nature and gravity of accusation, severity of punishment, danger of accused absconding or fleeing if released on bail, character, behavior, reasonable apprehension of witness, danger. Para 30, Lordship. Lordship, in this regard, may I submit, Lordship? In this regard, Lordship, I would like to rely on a judgment of Rajasthan High Court, where this particular case, Jagdish Singh versus Ashish Mishra, was appreciated, Lordship. May I take Lordship to relevant para, Lordship? That is with regards to this particular section. Para 13, Lordship. May I read, Lordship? A bare perusal of the above provisions would reveal that there is no provision provided in statute whereby the victim is required to be made a party respondent in bail application. However, Section 439, subsection 1A of CRPC was inserted by Act of so-and-so with effect from so-and-so, which makes presence of the informant or any person authorized by him obligatory at the time of hearing of the application for bail to the person under subsection 3 of Section 376, Section 376 AB, Section 376 DA, or Section 376 DB of Indian Penal Code. Thus, the statute only provides for giving opportunity of hearing to the victim in cases relating to some of the sections pertaining to the offenses of rape. Had it been the intention of the legislature, it would have in unequivocal terms mentioned in the statute itself about impleadment of the victims as a necessary party in all cases. And may I, in Padma Sundara Rao versus so-and-so, where the apex court has observed that the rival place regarding rewriting of
Where this has been referred?
and last para, Lordship, para 22, Lordship. May I read, Lordship? None of the members of the bars have supported the view taken by the learned single judge in Neetu Singh versus State and vehemently opposed the said order.
Para
22, Lordship. Last page. None of the members of the bar has supported the view taken by the learned single bench in Neetu Singh versus State and have vehemently opposed the said order whereby discretion has been given for impleading victim as a party respondent. The right of the victim as well as the accused person shall be rightly balanced, and any inclination to either of the parties would not subserve the fundamental principles of fair trial. Therefore, it shall be kept well within the minds of the legislature as well as the judicial discipline that while granting any right to the victim, right of the accused shall also be protected at very first instance. We are of the clear view that neither the statute directs impleadment of victim as a party respondent nor the judgment of Jagdish Singh and others versus Ashish Mishra, the one which we have just referred. Motion. directs impleadment of victim as a necessary party. Jagjit Singh and others case only provides the victim has a vested right to be heard at every stage of proceeding. Therefore, we are of the considered view that victim is not a necessary party and is not required to be impleaded as a party respondent in bail application under section 437, 438 or 439. Therefore, Lordship, my humble submission is since section 439, subsection 1A does not, that rigors of that section 439, subsection 1A would not apply. Victim, in fact, hearing the victim or any authorized person, it's not mandatory, Lordship.
But you have impleted.
Yes, of course, Lordship, I have impleted, but the issue is, Lordship, they are not participating. They are not even coming before the trial court, despite service of summons on various occasions, Lordship. That is why this matter has been pending, even this particular bail application has been pending for months, Lordship.
How many months, how many days you are in custody?
Lordship, 268 days. 268 days already in custody. FIR was lodged on 15/9/2023, and I was arrested on the same day, Lordship.
But then I don't agree with this. As per Jagdish Singh, it has to be.
Lordship,
It says, law doesn't require that the victim or the should be a made party. But Jagdish Singh says something else.
Lordship, this Lordship may kindly appreciate that this particular judgment of Honorable Apex Court, it was rendered on April 18, 2022.
Yes.
Thereafter, our Honorable Division Bench of this Honorable Court, Lordship, it has rendered its judgment on 23/6/2023.
Saying what?
Saying that only those offenses where there is POCSO, Lordship, may I take Lordship to para 8, Lordship? Para 8 and para 9 is relevant. Here, Lordship, the Honorable Division Bench has it has said that only those offenses where the offenses are under POCSO Act and those covered under section 439 subsection 1A of CRPC, then only it is necessary, the parties, victim or the authorized person is necessary to be heard, Lordship. May I read, Lordship?
Yes,
Para 9.
have you seen this? Division bench judgment.
Lordship, here, Lordship, as per my understanding, Lordship, this is for the POXO matters, Lordship, not for
Read
the
it
others.
properly.
This guideline which have been mutatis mutatis replied by Delhi High Court to cases arising
No,
from
no,
POXO
page,
Act.
come to page, what is this? Page 7. In every bail application, criminal appeal, arising from cases involving offences under POXO Act and those
Those
covered
covered.
by section 439(1)(a).
That's why,
CRPC.
Lordship. Here, Lordship, this is not covered under section 439(1)(a), Lordship.
Yes,
Lordship, here, Lordship, this is for the, as per understanding, offense under section, under POXO Act, and those covered by 439(1)(a), CRP registry
See.
cell, Lordship.
all the cases involving POXO Act, that is one part.
Lordship.
It is mandatory. Then other one is those cases covered by section 439(1)(a). What are the cases in 439(1)(a)?
Any Lordship, matter which
And
is
obviously not,
triable by the
not-
High Court, Lordship.
not 37662. What are the offences? 439(1)(a). It's not all the 376, particular 376. Few of offences.
Subsection 3 of 376 and section 376 AB and section 376 DA or
Yes.
section 376 DAB.
Yes. Not 376(2). This is a case of 376(2), present case.
That's actually 2 is also not applicable as per the Lordship, this offense Lordship. It may be Lordship wrongfully they have implicated law because 376 is their Lordship. 2 is not attracted Lordship.
See, what are the offences? It's not 376. There are so many offences.
Lordship, here,
Category of offences. It doesn't say only 376.
Lordship, here Lordship, law can
You
be,
have read it,
Lordship, Lordship.
439(1)(a).
Those covered by section 439(1) CRPC, the registry shall serve a notice of such bail application, criminal appeal, criminal revision to the public prosecutor therein, same investigation officer, consults officer in charge to mail, apply the victim guardian support person regarding financial proceeding before the High Court. In every such bail application, criminal Lordship, here Lordship, in every bail application, criminal appeal, criminal revision, criminal petition arising from cases involving offense under the POXO Act, and those covered by section 49(1)(a) CRPC, that is to say, section 4(1)(a) CRPC Lordship, is a Lordship that any person accused of offenses which is in the criminal procedure Lordship, bail is upper in the subsection 3 of the section
What are
437
the
Lordship.
offences? You read it. 439. This is CRPC.
Lordship, in a CRPC Lordship, one is Lordship, a High Court or Court of Session may direct a Lordship.
Number 1, subsection 3 of section 376
In section 376 AB or section
or
376 DA.
376 AB or section 376 DA or section 376 DB. That's all. 1, 2, 3, 4.
Lordship,
It
it is
doesn't say
Lordship,
376.
it doesn't say Lordship, only Lordship. It is any bail application, those are covered by just HSL. It can be Lordship 476 also Lordship. It
What-
cannot say there's only to those Lordship and not the others Lordship. And also what about the Lordship victim right under Article 21 of Constitution Lordship? At the citation lordship, I have Ferus lordship, the Assis, Mr. Jagdish Singh versus Assis Mitra. It is, practically it is mentioned that victim rights to be heard. It cannot be denied.
You read the sentence, the offense of the informant, the presence of the informant or any person authorized by him shall be obligatory at the time of hearing of the application for bail to the person under subsection 3. So and so, so and so.
Lordship, it
That's the reason our division bench has said offences involving POCSO and those offences provided under or covered under 439(1)(a).
Lordship, may I lordship, para 9 lordship, we have to start from reading from the start process. These guidelines which have been mutatis applied by Delhi High Court cases arising from POCSO Act are thus fit to be adopted for the proceeding in the Guwahati High Court and the benches. Thus, we further expand the scope of these directions and mandate that this would also apply to all proceeding, which
Yes.
criminal appeal, revision, criminal proceeding filed in cases arising from the prosecution under the POCSO Act. Thus, in order to amplify the scope of guidelines, the following step measures shall be added to the ones already formulated by the Delhi High Court. In every bail application, this arising from cases involving offences under the POCSO Act, and those covered by lordship.
Covered by
Lordship.
439. What covers,
But-
what the offences are there? Subsection 376,
That means
376
lordship-
AB, DB, 4 offences.
Then other lordship, then other,
Others not.
then what about this lordship, this Jagdish Singh
This
versus
is a
Asim Mera lordship?
common thing that he or she has, the victim has the right to be, has the
That's why lordship.
right of hearing.
Because Article 21 is their lordship, it cannot be increased lordship. Law can be lordship is upon the interpretation of the lordship.
I'll interpret it, what's there. We cannot enact the law, we interpret the law.
That's why
We
lordship. But
cannot-
Article 21 is always their lordship. It cannot be changed lordship.
That's the reason that Assis Mishra and all those,
That's why
that's
lordship.
why victims are there. In not all the offences, I think.
Here lordship is not categorically just lordship, that offense is lordship mentioned. There is only right of the victim lordship. It is
We'll
mentioned there.
mention it, we'll mention it.
And lordship, moreover, lordship in the article, paragraph 30 of this judgment lordship,
What is it?
lordship, it is said that, may I lordship, however, it is equally incumbent upon the High Court to exercise its discretion judiciously, cautiously, and strictly in the compliance with the basic principle laid down in a plethora of decision of this court on the point. It is well settled that among other circumstances, the factor to be borne in mind while considering an application for bail are whether there is any prima facie or reasonable
No, we
ground
are
to
yet
believe.
to enter that. Where on the presence of
Lordship,
victim at this stage. We are yet to reach that stage,
lordship.
whether bail can be granted. Yes,
May I proceed?
come to the merit.
Lordship. Lordship,
Just, we'll just first record it. Heard Mr. Learned counsel for the applicant. And also had MS El Hage learned additional PP for the state. Next paragraph. Considering the issue raised by the learned counsel for the parties with regard to the, with regard to, having been regard to the presence of the victim in view of the section 439(1)(a, I deem it appropriate to consider the same before entering into the merit of the bail application. Please stop. This Assis, where is, which page you are relying? Paragraph?
Lordship,
You quote them.
para 19 also, Lordship, para 19, 20.
No, one by one, just wait.
Para 16, Lordship, vamos a hacer para 16.
Section 439, 1A, huh? Capital A. Provides that the presence of the informant or any person authorized by him shall be obligatory at the time of hearing of the application for bail to the person. Under subsection 3 of section 376 or section 376 AB, capital, huh? Or section 376 DA or section 376 DB of the Indian Penal Code of 1860. On next para, we are reading of the above provision. The presence of the informant or any person authorized by him is mandatory at the time of hearing of the bail application to a person under offenses under the particular offenses of section 376 IPC, particularly subsection 3 of section 73, then section 76 AB, 76 DA and DB. Huh? Listen. Next, in the present matter, so the victim has been entered as party respondent. Number 2, Mr. A Tata, learned counsel for the petitioner submits that the victim is not mandatorily required to be heard in view of the specific, in view of the unambiguous provisions of section 4339 1A. Christopher. He submits that because of the service, because of notice, no, because of non-completion of the notice upon the respondent number 2, the bail application is pending for consideration for last, when, how many days? When did you file this?
Actually, it was first listed on 1/2/2024.
Since
February.
1/2/2
Yes, Lordship.
was listed on
February, 1 February. First.
since 05/01/2024. Which has deprived the accused from consideration of his bail application, who is languishing in jail since last 280 days.
268.
268 days. Mr. Yes, then counsel for the learned counsel and relying on the judgment of the division bench of this court. Submits that the requirement of hearing or presence of the victim is in a bail application would be only those cases involving offences under POCSO Act than those covered by section 439 1A CRPC. 1A should be within bracket, huh? 1AA capital. Therefore, he submits that even without service of notice to the respondent number 2, comma, bracket, oblique victim, bail, the bail application may be heard. Next page. On the other hand, MS L. Hage, London Council, London additional PP, while relying on the judgment of the Honorable Supreme Court in the case of Jagdish Singh versus Ashish Mishra. Reported in
18/4/2022 loss.
Find out the reported in
Lordship, 2022 9 SSC,
2022.
9 SSC,
9 SCC
321.
321.
321. Submits that.
The victim's right to be heard.
In every bail application, victim is to be included as party. No, in every criminal proceedings, including the bail application, the victim has to be included as a party respondent. And the hearing in the presence of the victim is mandatory in view of the above judgment, as well as the provisions of under section 439 1A.
Under 439 lordship, actually I am submitting 439 lordship. 1A I cannot, because 1A especially it is mentioned lordship. But for me, lordship, any bail proceeding lordship, victim's right may be heard lordship.
No. 439 application,
Lordship,
then by amendment in 2018,
no, sir.
439 1A has been inserted,
Lordship.
where it says 4 offences under 376 will be.
But what is it, 2018 was amended, but later on 2022 lordship, this judgment lordship is clearly indicate that victim's right cannot be neglected lordship. Article 21 is their lordship. That is the interpretation was done lordship.
Yes, what do you say, Mr.?
Your Lordship, when impleadment comes, then it's obligatory. So far as 439 subsection 1A is concerned, it in fact doesn't speak about impleadment. That was interpreted by the Delhi High Court, and basing on the mutati mutandis, our Honorable High Court has went to the extent of impleadment. Otherwise, Your Lordship, no doubt the victim has a participatory right, as my learned sister has said in the Jagdish Singh matter. But participatory right doesn't mean the victim has to be impleaded. Now it is upon the court whether the notice has to be sent or not. Otherwise, implement is mandatory. So far as for these specific sections are concerned, Your Lordship, which are mentioned in 439 subsection 1A. If the offence are not fall within the ambit of this section, then Your Lordship, this is not obligatory. Even because Your Lordship, the Jagdishing matter has only declared the participatory right, but its enforcement has not been guided. No guidelines have been laid down how to enforce it, Your Lordship.
Yes.
That's the issue here.
Therefore, our division bench has said,
Yes, Your Lordship.
in every bail application, so and so, arising from cases involving offences under POCSO Act,
Yes, general one, in all boxes.
And-
Yes,
and those covered by section 439 1A,
yes, Your Lordship.
the registry shall serve a copy to so and so, every such bail, every so and so, filed in it shall be meant to include the victim so
Yes.
and so.
In other offences, it's not required, Your Lordship.
Yes.
It is not meant. Yes, Your Lordship.
That's what I'm saying. Offences involving under under POCSO Act,
Yes,
as well as offences under,
yes. 376 subsection 3, gang rape, other offences, which
Yes.
is specifically mentioned in this.
yes,
This is statutory.
not other cases.
Yes, yes.
Here is a case, charge has been 376 2.
Yes,
Subsection.
it's not required.
Yes, that is what I were interpreting.
Yes, Your Lordship. Otherwise, Your Lordship, Jagdishing matter only declared the participatory right, but
That's what I'm saying.
enforcement is not been
Yes,
mentioned.
Jagdish Singh, it has to be participatory, it should be hard and all everything. General law has been laid down.
Yes, yes.
But then so far the implement mandatory presence, that has been clarified.
Yes.
Rajasthan, this is what, Rajasthan High Court. Rajasthan High Court, of course, they have gone it to the extent of saying that it has no application. But our division means is very clear.
Okay.
That, what was that? Above judgment, so and so. Are you saying so in view of the section, you are not relying on section 439 1A?
No, Lordship, actually, for Jagdishing Lordship, I am just relying that the victims right to be heard, Lordship. That's it, Lordship.
See, further submits that the victim has then mandatorily, victim has a right to be heard mandatorily
Lordship,
in
here,
a
Lordship.
cases involving in a bail application under section 439 CRPC, right?
Lordship.
Then
Lordship, here, Lordship, para 19, Lordship, in this matter.
what
it
that
is-
says.
Here, Lordship, it is said that it to be implemented, victim may be implemented part in every criminal proceeding where the charges punishable with 7 years imprisonment or more, Lordship. Here, Lordship, as per this section, Lordship, it is more than 10 years, Lordship.
According to her, it is, according to her, apart from section 439 1A, if the offense is, if the offense is punishable for
Okay.
more than 7 years,
7 years.
the victim has to be implemented as party respondent and her presence is mandatory. Consider the submissions and I peruse the judgments as referred to above. Please stop. The, on consideration of the submissions and the perusal of the judgment referred to above, in the case of Jagdishing Supra, no doubt the Honorable Supreme Court has laid down the participatory right of the victim to be heard even in every proceedings, including at the time of consideration of bail application. Please do. The the Honorable Division Bench of this court has clarified in the case of Deepak Naik versus State of Assam in criminal appeal within J bracket clause 40 of 2022 that in every bail applications, criminal appeal oblique criminal revision oblique criminal petition arising from cases involving the offences under the POCSO Act and those covered by Section 439 within bracket 1A CRPC. The registry shall interrelate in every shall be mandatory to implement the mandatory to implement the victim oblique guardian oblique support person as the case may be. Listen. Taking into consideration of above judgment of the Supreme Court as well as division bench of this court as and the division judgment of this order of this division bench of this court coupled with the provision of section 439 1A, this court is of the view that implement of the victim in all the cases, in all offenses, involving in all offenses, except the offenses involving involving under section and all cases involving offences under POCSO Act and those covered by section 439 1A CRPC, the presence or hearing of the victim is not mandatory. However, it doesn't mean that the victim has or the, has no right to be heard if she or her authorized person is authorized to, authorized person is willing to participate in the proceedings. In the present case, though the victim has been implemented as party respondent number 2, a notice has also been issued. However, no report is yet to be received. Listen. The offense charged in the present case is, what is that? Under section 363 oblique 376.
Subsection 2.
Within bracket 2, within bracket Z, bracket close, oblique 506 34 IPC. Having considered above, since the offense charged against the accused does not involve the offenses mentioned under section 439 1A of the CRPC command. No, there's no requirement of come on, no. No, the presence or the hearing of the victim would not be required. Accordingly. No, let's. Next paragraph. Having held above, this court would proceed to consider the bail application on its own merit. Then we'll see, go further. Then make your submission on merit.
Lordship.
So I've said, I've considered your submission also, but according to this code, if the victim or the authorized person is willingly wants to participate in the proceedings, there may not be a bar. But mandatory requirement, the presence would be in a cases involving POCSO Act as well as the offenses provided under Section 413 and 1A. Right?
I have no.
Am I
issue.
correct? That's my view, and that is what I've understood. Yes. So why you should be granted bail?
Lordship, Lordship, FIR was lodged on
May Lordship also be recorded that regarding the non-participation of the victim Lordship, her this address is Lordship is changed Lordship. So she may not be get the information.
In her semi, before the prayer may not be released before that. Yes. She further submits that since the victim and the informant have changed their location, changed their residential location of residence. Come on. Could be a reason that the victim and the informant are not participating in that. Then you write that, huh? And the records, where is the records? Come on. It is true that the offense, the nature of the offense, at least charged against the accused, is serious in nature. List of the at the same time, the long incarceration of the accused has to be considered. List of next page. The allegations are serious, however, considering that the charge sheet has been filed and the trial has already begun, this court finds that no custodial interrogation would be required in the present case. List of since the trial has already begun, the accused should also be given an opportunity to defend himself. there any material?
Lordship, yes, Lordship. The co-accused Lordship,
Hmm?
his statement is there, Lordship. Is clearly indicate that the
Where is the
Lordship is
the-
there, Lordship.
two witnesses, statement of two witnesses, PWC?
One is Lordship, the co-accused Lordship, which is a handyman, and other is Lordship, the lady Lordship, where they have stayed for hall for the dinner, lunch, or something like that, the restaurant owner Lordship. Only these two, the position was Lordship recorded on. Accused deposition is also been need to be recorded Lordship. Before that Lordship, granting bail, he may be every possibility Lordship. And then the granting bail at this Lordship.
That I've
crucial
recorded.
time.
I've recorded submission. Let me
That's-
decide now.
Lordship, at least Lordship, accused statement we recorded Lordship. After that, the court has any discussion Lordship.
Which one?
Lordship, accused statement Lordship, deposition not been made Lordship.
Where it is?
It is not there Lordship. It is not been recorded yet Lordship. That's why Lordship.
Lordship, it can be only recorded when the prosecution witness evidence is over. Now, even the
Lordship can
informant-
see the Lordship, prima facie Lordship, well-established case Lordship. Lordship can go to the 161 statement also. This all the corroborating Lordship, and Lordship, the co-accused Lordship who was with him Lordship at the time of incident. He also revealed that the accused was the one who committed the crime. Even Lordship, that material also been found Lordship. Then every possibility of conviction Lordship is there Lordship.
Next para. In the, under 164, the statement under the victim has clearly 160 stated that the inside the moving part, the accused threatened to kill her by showing a message, thou, huh? And forcefully undressed the victim. And then had after the sexual intercourse had pushed her out from the moving truck, for which she sustained injury. Yes. Having considered the materials, the on records come up. This court is not inclined to grant bail to the accused person. As not only the offense is serious, but the manner the accused has committed the crime. Committed the crime. Cannot be tolerated in the facts of the present case. That is what the what the Other 5 persons, other 5 PWs statements are to be examined before the court. Therefore, considering the seriousness and the materials against the accused, the bail application is stands rejected.
Obliged.
Deeply obliged.
Inhuman.
Please, my lord.
Yes.
My lord, all these applications, my lord, what I've been informed is that, my lord, they have submitted the final report, my lord. So in view of that, my lord, this applications have become infructuous, my lord.
Is it so? Yes.
Lordship, that may be recorded, Lordship. Since they are saying that FR has been filed, Lordship. So that part may be recorded, Lordship.
What's the issue?
Lordship, issue was way back in the year 2019, Lordship. SIC vigilance case
FR
was.
has been filed.
Yes, ma'am.
Has it been
FIR.
accepted?
Well, no, that is what I've been instructed, my lord, by the IO, my lord.
Where are you from?
Lordship, UPR Session Court, Lordship.
Yes, from UPS Session Court. He is a special PP in NDPS.
So for preference you are giving.
Sorry, Lordship.
This same FIR.
Yes, ma'am.
Lordship, all are same.
Ask Mr. Judge in learned counsel for the petitioner. Same order but separate order.
The same as
Right?
Mhm.
Same order but separate order in every case. Name will be different. Judge in learned counsel for the petitioner. This is an application under section 482 of CRPC. Come on, 1974, quashing of FIR number 62 of 2016 under section 409, public 34 of IPC, and the all of PS case number, huh? All of PS case number, huh? 62 of 2016. Is it so?
Earlier it
Lordship.
was registered in Alo,
It is all of PS case number or FIR number?
FIR number, Lordship.
but then it was transferred to the SIC.
No, we'll come to FIR number. Is it
FIR
FIR number?
Yes, Lordship. This FIR number 62 of 2016, Lordship. It was re-registered, Lordship. SIC.
Which where it is?
Lordship, SIC vigilance PS case number 11 of 2019, Lordship. It was re-registered, Lordship.
Re-registered as SIC within bracket, vigilance bracket close, PS case number 11 of 219 under section 409 public 34 of ICC, read with section 13 within bracket 2 of Prevention of Corruption Act 1988. Mr. Next para. Oh, Father, learned special PP submits that the what do we call it? The investigation has been
The final report. had been-
completed, which culminates into filing of FIR
Yes, ma'am.
before the court. Just in view of the above. It is stated at the bar that the criminal petition has become infructuous.
My lord.
Is it so?
Lordship, since FIR has been filed, FR has been filed, Lordship, will not fresh
That's why,
continue the case.
that's what I'm saying.
Lordship, yes.
It is stated at the bar. In view of the above, the matter has become infructuous. Accordingly, criminal petition stands dismissed, having become infructuous.
Lordship, instead of dismiss, can it be closed, Lordship?
Closed.
Much obliged.
Always.
Same order but separate order. Alright.
May I, Lord? Lordship, I appear on behalf of leading counsel M. K. Singh. He is not able to attend today, Your Lordship. And Your Lordship, matter may be passed appropriate, Your Lordship.
Heard, Mister? No, it's okay. Heard, Mr. So-and-so, and consequently. No, it's okay. Office note dated 07/02/2024 reflects that a record in respect of Sonam 2 and 3 have been received back. Mr. Next para. The service of upon respond number 2, therefore is complete. List for
Admission hearing.
admission hearing after 3 weeks.
Highly up.
No, please, Your Lordship. Lordship, here, still the status report of the IO of the case has not yet come.
Yes. This is what?
This is a application under section 482. CRPC for setting aside and quashing of FIR dated
So service complete.
service completed. Even the respondent number 2 have filed their affidavit.
Okay, so
After status report, better may be fixed for hearing.
list this matter for admission hearing. The learned additional PP, Mr. G. Thado may to obtain status, updated status of the case. All right? Okay. Continue. We'll finish it first. We'll finish it. Beleg matter.
Lordship, this is a joint petition filed by both.
Mr. B. Arun,
Lordship.
learned counsel for the petitioner, and Miss MS is in learned additional PP for this thing. Still copy of the LCR is received. List for admission in after a week. Or is there any urgency, Mr. Arun?
Lordship.
Is there urgency is there? There's no urgency.
No. I have another matters there at the session court.
No, I'm just asking. Other will this hear and dispose it of. There's no urgency.
No urgency.
Okay. Next.
Your Lordship, in this matter, leading counsel, my colleague, Gamhen Bam, wasn't able to turn up today. So, however, during the last occasion, the city were called for.
CD has arrived, Lordship.
So what is to be done today?
Your Lordship, since leading counsel is not present today, so
Mr.
Tabat Tukur.
Your name?
My name was not there in Your Lordship.
Your name?
Tabat Tukur.
Tabatudu.
Tokur. Tabat Tokur.
Tokur.
Tokur, T-O-K.
Learned counsel for the learned counsel appearing on behalf of Mr.
Jibam.
G. Bam. Submits better be adjourned for another 2 weeks. Praise the Lord. MS El Hage learned additional PP. Submits that she has received the
Case diary, Lordship.
case diary. List after 2 weeks.
Like,
Much more.
sir, retain, Lordship, or I will send it back, Lordship.
The
The original
2
case
weeks,
diary,
2
Lordship.
weeks. In that case, you return.
Lordship.
As submits that she has received the case diary. Since the learned counsel or the petitioner has sought for an adjournment and same has been allowed, case diary may be returned. And place it before, place the same before. Produce the same before. On next day, not before, on the next day.
Obliged.
Obliged.
May I please, Your Honor? This application IA has been filed for alteration of order dated 10/5/2024. Your Honor will find at page number 9 of the petition, Your Honor.
What sort of alteration?
Your Honor, on the last paragraph, Your Honor, you'll see that it is mentioned that pending production of the scanned copy of TCR, the proceedings of GR case number 1/2018, pending before the Learned Sessions Court, Bombilla shall remain stayed. However, instead of Learned Sessions Court, it should have been the Learned Court of Chief Judicial Magistrate, Bombilla.
Chief Judicial Magistrate Bogdela.
Yes, Your Honor.
Why you have not corrected that on that day? Yes.
Yes,
Minor mistake.
It is Judicial Magistrate Bhumdil.
This is an application. Heard MS so-and-so learned counsel for the petition. And Mr. G. Tado learned additional PP for the state. Next para. This is an application for, what do we call it? Correction.
For correction, alteration, Your Honor.
Correction of the correction in the order dated 10/05/2024 passed by this court in what is called criminal petition number 49 of 2024. Mr. It is seen that the it is evident that in the said order, instead of the Chief Judicial Magistrate it has been wrongly mentioned as Learned Sessions Court. Accordingly, the last para of the order, the court's Learned Sessions Court be replaced by Learned CGM, Chief Judicial Magistrate. Accordingly, the IA stands allowed in disposal.
Yes.
That's all.
Oh, that's not.
Would be obliged.
You're praying for time.
Yes.
Objection not yet filed. Anyway, on the prayer of Mr.
B. Sibo.
B. Sibu, Learned Counsel for the petitioner, respondent.
In I respondent.
You are supposed to file an objection.
Yes.
What is the IA?
I is for impeding the parties.
Are you filing?
Yes, senior instruct me some more time for
Anyway,
filing. for
or MS T.Y. Bhutia, Learned Counsel for the applicant petitioner. Next prayer, Mr. T. Bush.
T. Thakur.
You,
B. Sibo.
B. Sibu,
Yes.
Learned Counsel. Appearing for Mr. T. Taki. You are also a counsel in this matter? No.
No.
Learned Counsel appearing on behalf of Mr. T. Taki, Learned Counsel for the petitioner. Submits that Mr. T. Taki, who is appearing for, who is leading in this case, who is the leading counsel in this case, has some personal difficulties for which he prays for listing the matter after 3 weeks. Praise the Lord. List after 3 weeks.
Perfect. I would like to mention item number 5, and I would like to fix the date of item number 5. And your lordship, if interim may be granted, then it would be much better, because whenever he appear before the IO, then IO may arrest him if not granted interim. At least 1 week interim may be granted to the petitioner, your lordship.
You could have done, and we have already heard you and all.
At least please,
Next week.
Yes, the matter has been fixed after a week, Your Lordship.
Will give the date. Item?
Item number 5.
Yes.
Your lordship, at least 1 week interim may be granted to the applicant, your lordship.
Because you are not cooperating. This sort of activities will need to curb it. We need to curb these such activities.
He will cooperate, your lordship. That time he was out of
Come back.
station.
You appear and come back.
No,
Grant
if
you.
he appeared, then he might get arrested. He will definitely.
No, there is
get-
no question of re-hearing again and again. You could have all this
please, your lordship,
argument you have done.
at least 1 week
the most-
interim.
Sorry,
1 week interim may be granted, your
you
lordship.
just fix the date.
17th.
It is not done. Yes, item 1. Number 1.
Like,
May Your Lordship. Your Lordship, I have talked to the respondent counsel, and he has given his consent for day after tomorrow. Your Lordship.
It's not his consent. It's of 2012 matter.
Yes, Your Lordship. But unfortunately, the conducting counsel is not here. He is at rowing, and he has instructed me to pray for
On the prayer of Mr.
E. Payang, Your Lordship.
E. Payang, Learned Counsel, appearing for Mr. T. Perthin, Learned Counsel for the petitioner. Submits that Mr. T. Perthin, Learned Counsel, had to leave Itanagar due to personal, due to a personal problem for which he prays for listing the matter after 2 weeks. List of.
Day after
It is
tomorrow.
informed that Mr. B. Picha, Learned counsel for the respondent has no objection, has consented for fixing the matter after 2 weeks. Mr. Having considered that Mr. T. Perthin, the counsel petition, has to attend some urgent issue, urgent personal problem. Come on. the matter is adjourned, the prayer for adjournment is allowed as a last chance. List this matter after 2 weeks.
Much obliged.